Hello, everyone. Welcome to our part 5 of 10 series conducted by Bryan Thomas, an expert in construction lien law. I'm Ariella Wagner, the founder of SunRay Construction Solutions. We help thousands of customers throughout the nation secure their lien and bond claim rights. So we're going to get started. So go ahead.
Sure, Ariel. Thank you. We're continuing today along our jaunt through Tennessee lien law. Today we get to talk about bonding. Quick reminder, there is a question box that you can send questions to. I'm happy to answer questions throughout the webinar or to take them at the end of the webinar or to take them later via email. So however you would like, send them on and we'll get your questions answered. All right, so here's where we are in the multi-part series. Please note future dates you'd like to join us. We're going to start again today really quickly, just hitting the highlights of where we have gone thus far. Tennessee lien law basics. We've got remote contractors and prime contractors in Tennessee. We've got the definition of what an improvement is, and that really you need a contract and an improvement for a lien in Tennessee. There are some limitations on what the lien can secure. For instance, you can't put in their attorney's fees. Big picture, Tennessee is pretty liberal on what can and cannot be liens. For a prime, they need to record the lien within 90 days to secure their priority, and they need to perfect a lien within 1 year to maintain their lien rights. Remote contractors are a little different. They've got the notice of non-payment, which we talked about, which is a rolling requirement, 90 days from the end of the month when the work or material is actually performed or delivered. Then we've got the notice of lien, 90 days from completion, and then the lawsuit and the attachment 90 days thereafter. So that's where we've had thus far. That brings us to what happens when there is a lien filed. What about the bonding relationships? So I wanted to start off today and talk about, for those of you who don't know, what is a bond? Essentially, a bond is a three-party relationship where a party, a principal, tells an obligee they're going to pay or they're going to have security to pay, where the surety is the party that actually provides that security. The surety does so based on an indemnity agreement with the principal. So if the surety has to pay, the surety's got an avenue to come back and collect against the principal. So that's what the bond is. It's really a form of securing payment or securing an obligation to pay. Tennessee, when we talk about liens and bonds, has a pretty unique feature compared to a lot of other states. And it's one that actually makes a lot of sense. And I've got the statute up on the screen for you. And what this does is it essentially allows a private job to be treated like a public job where there are no lien rights if a payment bond is in place. So you'll see on the screen here, the issue is payment bond has to be procured. It has to be recorded prior to commencement. It's got to be for 100% of the prime contractor's price. If those things happen, there are no lien rights for remote contractors in Tennessee. The rationale, well, it's the same as what we had seen in the federal system or even the state systems on public projects under the Miller Act or Little Miller Acts, which require the general contractor to post a payment bond to secure payment for the remote contractors. So Tennessee allows it, other states don't necessarily allow it. It is a way in which you can avoid problems at the prime contractor level with the owner getting upset if there are issues downstream with remote contractors. I've got on the screen also just an example. It's an AIA form of a payment bond. This is not the end all be all. This is one that is used, the 312. You see it over and over again just as a common industry bond. There's nothing in Tennessee that requires this one, but I put it on the screen to make this point to you. When a bond is placed and it is recorded pre-contract for 100%, then there are no lien rights. Everything we've told you about timing deadlines in Tennessee goes out the window. And I say that from the perspective of what happens is you're now controlled by the bond. If we're looking, for instance, at an AIA bond, the timings are sort of similar to what you see already in the Tennessee Lien Law Act. That said, there's nothing requiring those time periods. So there is something you need to be very aware of if you are a supplier on a project in Tennessee and a payment bond has been posted in lieu of lien rights. So just be careful there. Now, the other question is, okay, let's take this a little further down the road. Let's assume that we don't have a payment bond for 100% of the contract price that was posted pre-construction. Okay, if that doesn't happen, then why are we even talking about bonds? Well, there's a couple things that we have to talk about practically. What does a lien actually do? And these are really leverage tools for contractors, primes, and remotes to get paid. And how does that really happen? Where's that leverage come from? Well, typically, a lien is going to be a breach of the owner's financing agreement, whatever that looks like, and put them in breach, which will put a lot of pressure on the owner to clear the lien, whether that's payment, whether that's demanding a bond. There's lots of options there. So we've got to look at it from the perspective of, okay, there is some leverage there that a claimant, lien claimant, can get by placing their lien, but at the same time, if that leverage goes into the owner or a prime contractor actually obtaining a bond, you've got to remember that there's a cost to doing so, which is only going to escalate the situation further, potentially somewhat flip the leverage. So why would you get a bond? Well, you may have a contractual requirement if you are a prime contractor and the lien is filed by a subcontractor. Certainly possible. Second, sometimes it makes sense for one reason or other if you've got a fight with a lower tier supplier, or maybe a supplier to a supplier that decides to lien. You don't want it to get messy. You want to keep it between you two. You may choose to bond off the lien to release anybody upstream, whether that's an owner, a prime, another remote contractor that's above you in the chain. So there's that reason. The other is statutorily required. Tennessee does have a interesting wrinkle. You've got the statute here on the screen, and it allows an owner to force a prime contractor to bond a lien when the owner has already paid the prime for the portion of the work. There is this phrase you'll see at the far right side, or any part of it. I don't think we've had any litigation on that in Tennessee, but that little phrase is very interesting in the sense when an owner has paid a portion of a payment to a prime that should have gone to a remote that liened the property, but there is a dispute, maybe, for instance, a remote that says there was a change that the prime has passed up to the owner, as to whether the owner can then force the prime to bond off the sub's lien or the remote's lien. So there is this wrinkle. You need to be aware of it, particularly if you are a prime and receive a demand from an owner. That said, the breadth of it and the ability for the owner to really get a lot of leverage out this really depends on what or any other part of it is going to be interpreted to mean. That said, for the purposes of bonding a lien, know it's there, know that that is an option or a reason that a prime may have to bond a lien in Tennessee. All right. So if you have to bond a lien in Tennessee, how do you actually do that. There are actually two ways. And the first thing I want to make you aware of is that any person can bond a lien. It's not limited to an owner. It's not limited to a remote. It's not limited to a prime. Anyone can bond a lien. So what does that actually look like? Well, I'm going to start with option one. Option one is an actual lien bond, a bond that is specifically procured just in relation to the lien that is being bonded. The idea is when you bond a lien, the lien no longer attaches to the property. Instead, it attaches to the bond. So that frees up the owner from having to pay essentially twice, or makes the lenders happy in the sense of their security is the property and their property is now free. All right, so we've got to have a licensed surety. There's a number of places you can check on that, but most of the time that's a pretty easy check. The surety can tell you, you can verify it pretty quickly through the Department of Insurance. So assuming we have a licensed surety, what does it have to say in the bond? Well, there's not a ton out there. You've got the statute in front of you, the statutory language that governs. The big thing that I would point out to you is that the bond needs to satisfy any judgment. I think a lot of the practitioners in Tennessee believe that to be any judgment on a lien claim, not any judgment, period. That said, that is an open issue, but the point is you have to indemnify the party who liened if the party who liened establishes their claim. So once you do that, you've got to file it in the public record, same as you would have recorded the notice of lien. All right, what does that look like in practicality? Because there's not a ton of guideposts, it really comes down to individual forms. This is one that my partner filed a couple years ago that I had handy just to show you as an example. Everyone's forms look a little different. There's not a one size fits all here, and there's usually very little back and forth on what the bond actually says, so long as it is for the amount of the lien at 100% of the amount of the lien, and so long as it is securing the lien amount, and so long as we've got a good surety. Those are the ones, those are the real hot button issues that get checked. There's some other things along the way that could be challenged, but I'm going to roll back up one slide just to show you again. The definition here of what has to be in that lien is pretty vague. All right, so this is what it looks like, and I'll point you up here. You'll see the stamp of the recorder. Most counties have this, not all counties in Tennessee. The other thing I will note is whenever you're recording anything with the recorder of deeds, it has to have a preparer stamp. And actually, as of this year, you also need to start including email addresses in the preparer stamp. The recorder, if you don't, will softly remind you, sometimes writing it in and sometimes rejecting it, and send you a nice nasty gram reminding you of the new requirements for the email address in that block. All right, option two. So option one is we get the bond just specifically for the lien itself. It's 100% of the lien amount, and we record it. Second option, is there a payment bond in existence? And usually this comes into play where one of two things happen, where there is a payment bond at the prime contractor level, but somebody forgot to record it. But more often than not, it comes into play where there is a remote contractor payment bond. Typically, certain subs, certain prime contractors, or certain trades, certain prime contractors will require the sub to post their own payment bond for anybody under them. You see this a lot. Framing is one area that I see it pretty often, at least the request being made. What Tennessee law allows is if there is a subcontractor lien bond and there is a lien placed by somebody that would be covered by that bond, you can simply record that subcontractor lien bond and release the property. Same as you would if you went out and got a specific bond for the lien. But if that is already there, it can be recorded to simply release the lien. Same thing if there is a payment bond for the entire job and it just was not recorded at the beginning. It can be posted at this point. Now, this used to be a whole lot more complicated. What I will tell you is at this point, a lot of the complexities were removed, most of them in 2015, a couple additional rubs in 2020. Big difference is if you were going to use a payment bond to release a lien, in the past, you used to have to get 15% extras, which was essentially more than you would have to get if you went and got just a lien bond to release the lien. It was limited to who could do it, and more importantly, it had to be much broader. It essentially had to be a bond at the prime contractor level. These are all gone now. So again, I'm going to scroll back up to the requirements. So the requirements is essentially, look, if you've got a payment bond, whether it's at the subcontractor level, whether it's at prime contractor level, it can now be recorded to release a bond or release a lien that is filed by somebody that is covered by the bond. And there's not a lot of additional loopholes or issues you've got to watch and check. It's pretty simple as far as getting it recorded, so long as it is a good payment bond. Now, that leaves us with this. What happens when you bond a lien? And this is one of the questions that I get from both sides pretty often. What I would tell you, number one, is we talked about attachment in the lawsuit before. One of the things the statutes help clarify is if a lien bond is recorded, whether there's a bond recorded to release the lien, whether that's a lien bond or a payment bond, then there's no need to go through the attachment process. That is helpful. The other part of this that is interesting is whether or not the owner of the property stays a party to the litigation. That remains optional under the statute. The second part of it that I get in a number of cases is what we'll see in C. And the question always comes in this. So if the blank owner, prime contractor, whomever, provides a bond to release the lien, do we have to talk about all of the lien requirements? You know, did I properly comply with notice of non-payment obligations if I was a remote contractor? Did I record on the 90th day or the 91st day from a priority standpoint if I was the prime contractor? All those questions, they are still relevant. And the reason they're still relevant is statutorily, if someone bonds off a lien, the process of bonding off the lien does not waive any of their defenses. Instead, specifically, they do statutorily retain all defenses to the validity of underlying bond. So that's still there. You're not going to get rid of that because somebody bonds a lien. And I get questions on both sides of that. I don't want to bond the lien. I don't think it's valid. I don't want to waive anything. You know, that's a conversation I typically have with owners or some primes. The answer is statutorily you're protected here, CC. The other thing I would tell you is when I'm having the conversation on the owner and general contractor side, from the upstream side, there's this additional wrinkle in 5B that you see on the screen here. And it really forces a lien claimant's hand in the sense of if an owner or a prime or even a remote that's above the lien claimant is bonding off a lien and the lien claimant doesn't prosecute it after the lien is bonded, they could be liable for a lot of cost associated with the bond and the lien itself. So it's just an additional wrinkle that adds pressure to a lien claimant and says, hey, the money is here. Here's the bond. Typically, you see these in situations where there's real dispute on the lien. And it's, if you want to go forward, you need to go forward. If not, otherwise you need to pay me back all my cost for failing to actually prosecute this lien that you've slapped on the property. I tell you all that to tell you where we are with bonds and liens in Tennessee. Happy to answer any questions anybody may have, but that is it in terms of how bonds and liens interact in the state of Tennessee.
Wonderful. Thank you so much. And right now we do not have any questions, but if anyone does have any questions, please feel free to submit them in the box to the right. I think you answered everything in the webinar, Bryan. It's very, very informative.
Great. Look forward to seeing everyone later.
Thank you and have a sunny day, everyone.